Wow, again, it's creating problem. Let me see. You can see. Okay, I hope you can see the screen. No, we cannot. Okay. 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 We were here and then we finished this one. Okay. So we were, okay, this is the last case here. So Pharmaceutical Society of Great Britain versus Boots. So the court held that, I hope it's clear. You can see the screen. So court held goods on the shelf constitute an invitation to treat and it's not an offer. And a customer takes the goods to the counter and makes an offer to purchase. So the shop assistant then chooses whether to accept the offer. The contract is therefore concluded at the till, that is the counter, in the presence of the pharmacist. So this is all with the first slides, and now we will move on to see what is acceptance. Okay. Yes. So today, now we will move forward and we will learn about acceptance. I said offer plus acceptance is agreement. We have seen the essentials of contract. We have seen differentiation between offer and invitation to treat. Now we will move on to acceptance. Now, acceptance is an essential element of a valid contract and a valid agreement. So there has to be a party who accepts the terms and conditions which are adumbrated in an agreement or in a contract. So an agreement that is coupled with the fact of legal enforceability, as we said earlier, is a contract. So what is this acceptance? Of course, you know what is the meaning of it. Generally, what is the meaning of it? You already know acceptance in your mind. You already know what is acceptance. So acceptance is to signify assent or express one's consent or to do or not to do something. That is consent to, it's no or there. So it is acceptance basically is to signify assent or express one's consent to do or not to do something. I'm repeating, what is acceptance is to signify assent. Assent is simply means that yes, I'm ready to go ahead with this. Okay, to express one's consent is where you are giving permission to somebody. There's a slight hairline difference. You're giving permission to somebody and you're consenting. Yes, you can do it. Yes, we will do it. So assent is you are agreeing with it just directly, and consent is there is a kind of permission that is attached to it. Yes, I consent to these things. Okay, so acceptance is to signify assent or to express one's consent to do or not to do something. Now, why I've chosen the Indian contract law, though we are studying it in the international perspective, is because the Indian contract law is given a little bit, a kind of a detailed explanation about acceptance. What is acceptance? So the Indian contract law says that when the person to whom an offer is made signifies his assent thereto, the offer is said to be accepted. So it's like a simple statement. So thereby, only when an offer is accepted, an agreement and the possibility of it culminating in a valid contract kicks in. I'm repeating. Only when the offer is accepted, an agreement and the possibility of, culminating it into a valid contract kicks in. That's when there is acceptance, that's when the thought of agreement and the possibility of it, of it ending in a contract comes in. So when the offer is accepted, it becomes a promise. Listen carefully. When the offer is accepted, there is those phases here we are talking about. When the offer is accepted, it becomes a promise. Why? Because the other party says, yes, I'm willing to do what you are saying. It becomes a promise. More clearly, when the offeree to whom the offer is made signifies his assent, which means when he accepts the offer, this act of acceptance operates as a promise. I'm repeating, the act of acceptance operates as a promise to proceed with the agreement. Yes, I'm willing to move ahead with the agreement. Why? Because the offerer expresses his willingness to be bound by the term. So bound by the terms of the offer. So thus, acceptance is an important element in an agreement and a contract. So if you can see there on the slide, the word so, it's not so, it's off. I will just change it and then send it to you later. So thus, acceptance is an important element in an agreement and a contract. So therefore, a party should, signify their assent or express their consent. Now, what is a valid assent? What is a valid consent? We will see later. Okay. Who can give a consent? We'll see later. But what is acceptance? Is to signify their assent. Only when the party accepts the, the offer, that's where there is a possibility of an agreement and the probability of a future contract that comes in there. It might seem simple, but you need to know the definitions and you need to write the words exactly as it is, signifying assent or express one's consent. So these are two key phrases here. Signify assent, express one's consent. Now, what is the effect of acceptance? Once the offeree signifies his assent, it becomes a promise. And now the elements of offer and acceptance legally bind both the parties, the offerer and the offeree, to the proposed transaction. Now, who can signify assent? Now, for an acceptance to be termed legally valid, such acceptance must be expressed by the person to whom the offer is made and not the neighbor or anyone else. For example, say now, you decide to sell your car and there is B who comes, B who is interested to purchase, the car, and B for some purpose is not available. And then, say Mr. P calls you, who is B's friend, and says, my friend is interested in purchasing the car. Okay, it's just like when he communicates to you, it's just a communication, but it is not the acceptance of the offer, because the person who intends to buy it should signify the assent. Are you understanding? The person who's intending to be legally bound and to accept the offer and proceed with it, that person should signify assent, not anybody else. So what are the essentials of valid acceptance? Those are just in simple terms. What are the essentials of valid acceptance? One, acceptance must be communicated. Naturally, if you keep it in your mind, it's of no use, like you're not communicating it. It has to be communicated to the party. So for acceptance to be considered valid, it must be communicated by the offeree to the offerer that, yes, I'm willing to do this. Mental determination, accepting in mind without conveying or communicating it to the offerer is not a valid acceptance. Now, acceptance should be absolute and unqualified. It should be direct and unqualified. I mean, there should be no other factors attached to it. It should be yes. Then acceptance should be made in normal, usual manner, unless the offerer or the terms of the offer prescribes the manner of acceptance. So it should be normal, in a usual manner. Are you understanding me? We will discuss it with case law so that you'll understand further. The acceptance should be made before the revocation of the offer, before the offer cancels or before the offer closes. Acceptance should be made before that. Then acceptance must be within a reasonable time. In case the offerer has a reasonable time limit, it has to be within a reasonable time. Suppose, for example, there is there is a commercial offer for sale of some goods, some products. Say you must have heard a 15% discount, 10% discount, or whatever, 20% discount. So that offer is for a limited period of time. So suppose there's an offer, say today, and you go next year to purchase it at 10% discount, it may not be available. So offer must be accepted within, there's always a time limit. It must be accepted within limited time. So again, I'm repeating, acceptance must be communicated. There's something called as implied acceptance also, but for now, essentials of a valid acceptance, acceptance must be communicated, keeping in mind, and then saying, I thought of, it was a yes. So silence is no acceptance. Silence cannot be considered as acceptance. However, there are exceptions under the law of acquiescence or even the principles of contract, basic principles of contract, when silence can be considered as acceptance. But generally speaking, silence is no acceptance. Like, for example, A offers to marry B, and B just keeps it in her mind and does not communicate acceptance. And then A understands that B is not interested, waits for a year, and A gets married to someone else. So B now cannot go back and say, I was having it in my mind. Simple example. Next is acceptance should be absolute. It should be straight. It should be direct. It should be unambiguous. It should be made in normal, usual manner. The usual way of expressing the acceptance. See, in today's world, acceptance can be expressed by way of phone, mobile phones. WhatsApp also is legally accepted today, depending on jurisdiction again. WhatsApp is accepted in India, WhatsApp is accepted in UAE, WhatsApp is accepted in Oman, Sultanate of Oman. So it depends on the jurisdiction. Mostly, I guess it's accepted, but it depends again, because there are different laws across the globe, including like, North Korea has different kind of laws, so WhatsApp does not operate there. So you cannot include WhatsApp in that. So internationally speaking, again, it depends from jurisdiction to jurisdiction. In today's world, there are different modes of communication. You know it, phone, telex, fax, postal also, which is quite slow, but some people might say that, no, you have to, express your acceptance by postal mail, or it has to be by courier, or it has to be by email. So acceptance has to be communicated in the way, it has to be communicated, which is normally acceptable. And if the offerer mentions a particular way that acceptance has to be communicated, it has to go in that particular manner only. Like, for example, if the offerer says, you will have to send a fax to me, that means it is a fax. You cannot send it by email. So, I mean, you can send it, but in case he accepts, he approves of it rather, is fine. But in case there is a conflict later, and you'll want to, redress any particular right in case of infringement of your rights, you cannot get it enforced in the court of law. I mean, they can come up with a defense saying that acceptance was, they were asked to, express their willingness to accept the offer by way of facts. So it can happen. Then again, there are different ways of defending and arguing also, but I'm just telling you. Next is acceptance must be within a reasonable time, within a particular time frame. Now, acceptance may be expressed or implied or even conditional. Express is where you probably verbally articulate it or expressly send it in writing, typing or whatever, or it can be even conditional. I mean, if, like for example, what is conditional acceptance? A says to B, I will sell you this product, provided you pay for the delivery charges. So, that is conditional. So let's read the slide. Acceptance may be communicated by an act, by words, verbally, or in writing. It may be implied. That means the actions, by the actions you understand, that is implied. For example, when you board a cab or a taxi, it is understood that you need to pay the fare. When a condition is attached to acceptance, it is regarded as conditional acceptance. It is also referred to as qualified acceptance. I'm repeating, conditional acceptance is also referred to as qualified acceptance, and it may involve a counter offer. One offer, A agrees to sell B his horse, provided B agrees to sell to him his stable at location X. So there is a counter offer here. So, or P agrees to sell goods to Q, provided Q pays for the delivery charges. So conditional acceptance can be qualified acceptance. It can be also referred to as qualified acceptance. So you can also say that acceptance may be expressed, implied, or qualified. And there can be also a counter offer. So is silence acceptance? Generally, silence is not considered as acceptance. However, in certain circumstances, silence may be considered as acceptance. For example, suppose that A sends B some goods and A informs B that A expects payment. If B consumes the product or uses it, then B has impliedly consented to the agreement. So in some, like for example, say now A is having a cloth mill. A is having a cloth mill. B owns a garment factory. So A sends some consignment which has materials, and B is expected to pay, but B has a term in the contract, I will check the quality and then pay it to you. But what B does is he has transacted or probably contracted with somebody else to deliver some garments to the wholesaler now. Probably he has contracted, has some other contract, ensuing contract. So what he does, he checks the quality and immediately starts using the material, cutting and transforming it into a garment, whatever garment, clothes, he transforms it into garments. And then A asks for the money. Then B says, well, I told you that I will first check the quality. But here, B has already cut the material. So that is an implied consent. He already began using the product. He started appropriating the product for a particular use. So that means there is an implied consent here. There is an implied acceptance here. So in some circumstances where the parties have been dealing with each other and are acquainted with the dealings with each other, then silence may be interpreted as acceptance. I'm repeating. In some circumstances where parties have been dealing with each other, where they're used to each other, they're acquainted with the dealings with each other, silence may be interpreted as acceptance. Silence can be accepted or regarded as acceptance. Like for example, A and B, let me come back to this example, but in another way. A supplies, materials, textile materials to B, who owns a garment factory. So they have been dealing with each other, say for 6 months, 1 year, 2 years, 3 years. So they already know the mind of each other. So even if B does not get back, into, really expressing his willingness to go ahead with the product, that means silence may be interpreted as acceptance, again, depending upon the facts and circumstances of each case. Therefore, prior dealing may be an exception to the rule of silence. As per the law of contract, prior dealing may be an exception to the rule of silence as non-acceptance. exception to the rule of silence as non-acceptance. I'm repeating, it is an exception to the rule of silence as non-acceptance, where silence is not equal to acceptance. Silence cannot be considered as acceptance. So an exception to the rule that silence is not considered as an acceptance is prior dealing. Okay. Next is waiver of express acceptance, where the one party says that you need not really, expressly approve of this transaction. You need not expressly convey your acceptance. So that is an exception as well. And silence may be considered as acceptance. Next is a postal rule on acceptance, or a post box rule, once upon a time as it was called, or postal rule on acceptance. This is again an age-old, theory which got attached to the contract laws. Here, the offerees accept. Who is an offeree? To whom the offer is made, or to whom the proposal is made. Proposal, offer, is the same thing. So to whom the proposal is made, or the offeree's acceptance is good the moment the acceptance is posted. This is with respect to where acceptance is posted in the post box or in the post office. So it becomes effective the moment it is dispatched. That is, the moment the letter or acceptance is posted in the post box. That is the time or the date of acceptance. Now, how will you decipher that? Normally, post offices have, a kind of a seal that, imprints the date on the envelope or the parcel or consignment or the tapal, whatever word you want to use it. So they put a date on that, the date of dispatch. So the date of acceptance would be the date of dispatch in case of acceptance, which is sent by posts. So in Adam versus Linsell, 1818 case, I do not have the citation nor I had before. In Adam versus Linsell, just 1818 case, the defendant sent a letter to the plaintiff offering wool for sale and asking for a reply in the course of post. He said that you will have to send it to me by post. The letter then was misdirected by the defendant and arrived later than it would have been. The plaintiff replied at once, accepting, but the defendant having decided that because of the delay, the plaintiff were not going to accept and had already sold the wool elsewhere. Because, the acceptance came in late because of postal delay, this guy, he already sold the wool to someone else. So now here the plaintiff sued for breach of contract. The court held that to require a posted acceptance to arrive at its destination before it would be effective, it would be impractical and inefficient. It would be much better if as soon as the letter of acceptance is posted. So here the postal rule came in. So here they said that the date of the letter, dispatch of the letter would be considered as acceptance. So it would be much better if as soon as the letter of acceptance is posted, the acceptor could proceed on the basis that a contract had been made and then take action accordingly. Why? Offer plus acceptance is agreement. So here, acceptance, the moment it is dispatched, the moment the person, puts the letter in the post box and, there is the date of dispatch, which is imprinted or sealed on the tapal. So at that time, that is the date. The date of dispatch would be considered as the date of acceptance. The plaintiff therefore succeeded and the defendant was in breach of contract. The offerer to have a change in mind or withdrawal of the offer, made an offer with someone else is possible, but nevertheless, the court looked into the conduct. Business would be better served by giving the offeree certainty. Thus, the postal rule was created in Adam versus Linsell case. So this is an important principle in the law of contracts and it was attached to it. That is a postal rule of acceptance. That is the date of dispatch would be considered as the date of acceptance. Thereby, acceptance is effective on posting. Even if the letter is lost or delayed, the offerer is still bound. Next, we will move on to study the formation of contract in our subsequent classes. Now, in the formation of contract, we need to understand what makes a contract, which is already defined in the previous classes we have explained and in the previous slides. It is, lecture 1, we've already discussed. And for a contract to be valid, there must be a valid offer, a valid acceptance. It is offer with acceptance is an agreement and legal enforceability. When it is legally enforceable, we'll again study that is with a valid consideration and valid consent. Now, who can give a consent, minor's consent, all these things we will study in the subsequent classes. So consideration, what is consideration, is an essential part of the contract. Something of value that is given in return by the parties to the contract with intention of performing the contract is consideration. In simple terms, because this is just a slight introduction for consideration, and we will be studying consideration in the next class. We'll be studying consideration, we'll be studying past consideration is no consideration, just to give you a heads up into what we are going to study in the next class, so that you can probably, even all of you can read and come. For example, money paid for goods purchased is consideration. In the ensuing chapters, we shall discuss again consideration and valid consent. So that's all for today's class. Your attendance, and then you can ask me any questions if you have. But now I know you, everyone, so I know who's absent as well. Okay, so Abdul Rahman, Aisha, Issei, Hassan, Naima. Okay.
Yes.
Yeah. Yeah.
Yes. Morning, Mel. Well, I wanted to ask a question about the previous lessons. Assignment. I did not understand, for example, the question of consumer protection, about how to answer that question. That assignment.
The previous subject.
Yeah. Yes.
Okay, what's the question on that? How to answer it?
And because it seems appears like a simple question, and needs a simple answer, but I don't believe that. It needs a legal way of answering this question. For example, the two examples you have given, 1 or 2, talking about the supply of some product, and that was defected. So whether that object can be replaced or not, or whether he can take an action, proper action, a legal action, or something like that. So how can we answer that assignment talking about the, let's say, when some consumers buy some products from sellers, from the whole sellers, or maybe product producers, okay, what are their rights? Can they take an action, legal action, or they can get a replacement of the defective object or something like that? I don't know whether you have understood or not.
Yeah, but that is a different question altogether. Now that the subject is closed. I mean, now you answered the exam. I will reply to this, but now the assignment also is closed, and today it's like going to be totally wound up. I mean, the chapter is closed because now you are already into the next semester. So that is an old subject. Well, how to answer it, I remember, I think I'll go slow. I remember that I sent, a voice note to you on how to answer it. I gave you an easy form, that is the IRAC. I stands for identification of the problem. So what is the problem in the question that is given to you? That is, the product got, there was a defective product and there was no cash receipts that is issued to you. So that's a problem. The product got defective. So identify the problem. Then R is the relevant rule or the relevant law, that is the consumer laws. And you said that you'll also mention about UNO, how international, support is there in the field of consumer law, how UN also has got certain, conventions and treaties that are signed to that extent. And I've also given some points on that, on the UN, how UN supports consumer rights. And I said, if possible, if you want to, you can also make a reference to your local laws on how your country protects consumer rights. So I have not given any jurisdiction there. I've just given you a general question. So your answer, okay, IRA, application, how you would apply, you would speak about, the consumer rights, you would speak about cash receipts is a must. I gave you a detailed, explanation by way of voice note last time. If you want, I can resend it to you. And C is how you would draw conclusions. So long story short, the consumer has got the right to information about the product. He's got the right to be issued cash receipts. When you pay money, you're entitled to a cash receipt. And next is you will address your problem with the dealer. And when the dealer does not comply with your request, you would knock the doors of the consumer court or the consumer forum, whichever body is existing jurisdictionally in that particular area. So you would redress your complaint with the consumer forum within appropriate jurisdiction within a particular territory. So this was your answer.
Thank you a lot.
This is just a short form, but you'll have to keep writing. I mean, just I try to verbally say, convey it to you in brief. Yeah.
Okay. Yes, I've understood, of course. But is it possible that to sue? I mean, one party to sue the other party and take to court. Is that possible?
See, normally it's not the question about whether I'm going to, win a litigation. If I am wronged, I've got the right to sue the other party. Now it's for the lawyers to decide and to defend your case. How they're going to defend, and if you're able to defend your case best by, trying to give some other evidence that you can think of within the consumer area, saying that you could also say that I insisted, but he did not give me a cash receipt. But what if he told you to come and collect it and you have not collected? So you lose a right. Now in law, there's also, there is a maxim which says that, law is for the vigilant. That is, one needs to be vigilant about their rights. What is vigilant? It means to be alert. One needs to be alert about their rights. There's another maxim which says that one cannot sleep over their rights. That means you need to know your rights. And in case, even if the consumer goes to the consumer forum and he has no evidence, he has done nothing on his part to secure his rights, and it was expected of him to do so, so he will not win the battle. He will not win the litigation. He will not win the complaint. So it will go against him.
Yes, that's right.
So
thank you.
Law is for the vigilant. So it depends how you want to, reply to the question. You could, if you want, you can take this stance and say the law is for the vigilant. He cannot really claim it now because he was not, vigilant enough to get cash receipts. He was entitled to cash receipts.
Yes.
It's however you want to, approach the answer.
Yes.
For me, I normally give my students the leverage to approach the answer in the way it is, because I do not like mechanical answers that just as the law says it is like this, like this. What about the defense point? For me, it is like that. I do not know about other teachers of the same subject, but for me, I like minds that think, like for and against. Every time we cannot, but you are expected to quote the law and you can give, both the sides of the answer. For me, it's like that.
Okay, thank you.
Yeah, welcome.
Fine.
Okay, so that's it. So we meet next class Tuesday, same time. Bye-bye.
Thank you a lot.
Thank you.
Welcome. Bye.